When you make something new, it is a very special feeling. Maybe you wrote a beautiful song that makes people happy. Perhaps you painted a picture that shows your unique view of the world. You might have even invented a useful new tool that makes life easier for everyone. These creations come from your mind and your hard work. They are a part of you. Because these things are so important, it is also important to protect them. Protecting your original work ensures that you get credit for your effort. It also means you can decide how your creation is shared with others. This protection is fair and encourages more people to create wonderful new things. Imagine a world where anyone could just take your song and say they wrote it. Or picture someone copying your invention and selling it without asking you. This would not feel right at all. It would be discouraging for people who spend their time and energy on making new things. That is why we have rules and laws. These rules help us understand who owns an idea or a creation. They provide a clear way to make sure that the original creator is respected and rewarded. Understanding these rules is not just for big companies or famous artists. It is important for everyone, from students to small business owners. This essay will help you understand some important ideas. We will talk about what it means to protect original works. We will look at different ways that people might wrongly use someone else's creations. It is helpful to know the correct words for these actions. Knowing these terms helps you protect your own work. It also helps you be respectful of the work of other people. We will explore these concepts with simple explanations and clear examples. This will make it easy to see how these ideas work in our daily lives and why they are so important for a fair and creative society. The journey of creating something, from the first spark of an idea to the final finished product, is a personal and valuable process. Think about a baker who spends months perfecting a special cake recipe. That recipe is the result of their unique skill and countless hours of testing and tasting. The protection of this recipe ensures that their business can be successful because they have something special to offer. In the same way, a writer who spends years crafting a novel deserves to have their story protected. These protections are like a fence around your property, letting everyone know that what is inside belongs to you and should be treated with respect. Let's start by looking at the word infringement. Infringement happens when someone uses a protected creation without getting permission from the owner. This usually involves something that is protected by a special right, like a copyright. For example, a popular movie is protected by copyright. If you copy that entire movie and start selling it to your friends, you are infringing on the movie studio's copyright. You are using their property without their permission. Infringement is often about the unauthorized copying, distributing, or performing of someone else's protected work. It is a legal term that means you have broken a specific rule about using another person's creation. Next, we have the term forgery. Forgery is about making a fake copy of something and trying to make people believe it is the real, original item. It is an act of deception. A very common example is faking a signature. Imagine someone finds a lost check. If they sign the owner's name on the check and try to cash it, that is forgery. They are pretending to be the owner to get money. Another example is in the art world. A person might paint a copy of a famous painting, like the Mona Lisa, and then try to sell it as if it were the original one painted by Leonardo da Vinci. Forgery is all about creating a false imitation to trick people. Then there is plagiarism. This word is very important, especially for students and writers. Plagiarism is when you take someone else's words, ideas, or work and present them as your own. You are not giving credit to the person who originally came up with it. For example, if a student is writing an essay for school and copies a whole paragraph from a website without saying where it came from, that is plagiarism. They are pretending they wrote that paragraph themselves. It is like stealing someone's thoughts. Plagiarism is an act of academic or professional dishonesty. It is about taking credit for work you did not do, which is unfair to the original creator. These three concepts can seem similar, but their focus is different. Infringement is a legal violation of a specific right, like using a copyrighted song in your video without a license. Forgery is about creating a fake object to deceive, like making a false concert ticket to sell to an unsuspecting fan. Plagiarism is an ethical breach of trust, like using a friend's research in your report and claiming you did all the work. While all three involve using something that is not yours, the context and the intent behind the action are what make them distinct. Understanding these distinctions is the first step toward respecting intellectual work. So, how are creations protected in the first place? They are protected by something called intellectual property rights. This is a legal idea that says you can own things you create with your mind. Just like you can own a car or a house, you can own your ideas, inventions, and artistic works. These rights give the creator control over how their work is used by others. They are called intellectual because they come from your intellect, or your mind. They are property because, like physical property, they have value and can be owned. These rights encourage people to innovate and create, knowing their efforts will be legally protected. There are several types of intellectual property rights, but we will look at three main ones. The first is copyright. Copyright protects original works of authorship. This includes things like books, music, paintings, photographs, and movies. When you write a story, you automatically have the copyright to it. This means nobody can legally copy, share, or sell your story without your permission. Copyright protection usually lasts for a very long time, often for the entire life of the creator plus many more years. It ensures that artists and writers can benefit from their creative labor for a long period. Another important type is a patent. A patent is used to protect inventions. This could be a new kind of machine, a new chemical process, or a new type of medicine. To get a patent, the inventor must prove that their invention is new, useful, and not obvious. A patent gives the inventor the exclusive right to make, use, and sell their invention for a set number of years, usually around 20. For example, when a company invents a new smartphone technology, they can get a patent. This stops other companies from copying their new technology for a certain time, giving them a competitive advantage. Finally, there are trademarks. A trademark protects symbols, names, and slogans that are used to identify and distinguish goods or services. When you see the golden arches of McDonald's or the Nike swoosh logo, you immediately know which company it is. These are trademarks. A trademark prevents other companies from using a similar name or logo that could confuse customers. It protects the company's brand and reputation. For example, another shoe company cannot use the Nike swoosh on their shoes, because that would trick people into thinking they were buying Nike products. Trademarks help consumers know exactly what they are buying. Now we can see how these ideas are connected but different. Intellectual property rights, like copyright, are the legal foundation. They establish ownership over a creation. Infringement is the legal term for when someone violates one of these rights. For example, illegally downloading a copyrighted album is copyright infringement. Plagiarism, on the other hand, is an ethical issue. You could plagiarize an idea from a book that is so old its copyright has expired. It would not be illegal infringement, but it would still be plagiarism because you are dishonestly claiming the idea as your own. It is a breach of academic or creative ethics. Forgery is different again because its main goal is to deceive someone by creating a fake. You could forge a famous author's signature in a book. This isn't copyright infringement or plagiarism, but it is a crime of fraud. The key difference is the intent to trick someone with a fake object. So, you can infringe without forging or plagiarizing, such as when you use a copyrighted photo on your blog without permission. You can plagiarize without infringing, like using an old public domain text without credit. And you can forge without directly infringing or plagiarizing, like creating a fake ID card. Each term describes a unique kind of wrongdoing. Understanding these differences is very important in our modern world. Today is February 11, 2026, and we share information so easily on the internet. It is very simple to copy and paste text, download an image, or share a video. Knowing about these rules helps you act responsibly and ethically online and in your work. It helps you give proper credit to others, which is a sign of respect. It also gives you the knowledge to protect your own creations. If you know you have a copyright on your song, you will know what to do if someone uses it without asking you first. In conclusion, respecting intellectual property is about being a good citizen in a creative community. Whether you are a student writing a paper, an artist sharing your work online, or just someone who enjoys movies and music, these concepts affect you. Infringement is breaking the legal rules of ownership. Forgery is creating a fake to deceive. Plagiarism is stealing credit for someone else's ideas. By understanding the clear differences between them, you can navigate the world with integrity. You can celebrate and support the hard work of others, while also confidently sharing your own unique contributions with the world.